All right, good evening, everybody. Tonight we're going to be going through basically the course orientation. We're going to talk about how you are going to complete your assignment and what the expectations are for you to complete this course. What we're going to end up doing is, like I said earlier, everyone should have access to this Google Classroom here. Everybody should have access to this. If you don't, please send me an email after this class, and I will be more than happy to go through and explain to you what exactly is going to be. Get it for you going. Um, Now, one thing that you will notice in here is this is the course orientation and the syllabus. Everything that you need will be within this syllabus. In regards to your instructor, of course, everybody knows me, but some of you may be new. Of course, there's some information here and some helpful website that we will be using throughout this course. Your textbook is going to be right here. Now, not all of the courses that you're going to be taking is going to have a textbook. Those that do not have a textbook, you will be relying solely on my lectures plus PowerPoint. Okay. There is an optional reading called Think and Grow Rich for those of you that need extra credit to pass. This will be an extra credit assignment we will talk about. Your learning objectives for the first one that we're going to complete tonight. As you can see, there are 10 different learning objectives that we are going to be completing. So in this situation, what's going to happen is that we will be having the Texas contract law. We will be going through basically 10 different items that we're going to have. We're going to be dealing with to describe the composition and duties of the Texas Real Estate Commission, to describe the unauthorized practice of law and how to avoid it, describe the compensation and duties of the broker-lawyer committee, describe the rules and regulations regarding promulgated forms, explain and give examples of the exceptions to TREC's rules regarding the use of promulgated forms, describe the requirement of Section 5.008 of the Texas Property Code for sellers to provide a buyer a written notice of the property condition. 7, identify the exceptions to the seller's disclosure requirement. 8, explain why and when the seller has to provide this disclosure. 9, describe the buyer's rights based upon the receipt of this disclosure. And 10, describe how the Deceptive Trade Practices Act applies to real estate agents. So we will be completing all of these this evening, and we will be completing those and going into the course material. Again, like I said, the goal of this is we want to relatively get through the content quickly. And so one of the key things that we want to make certain of is that you have an understanding of each and every one of these different matters that are shown up here, and we will go through those. Again, if you have any questions at all, please stay on task. Missing a class in this advanced, fast-paced track class can put you behind really quickly. We are going to go ahead and jump on into basically our content, our PowerPoint for this evening, and then we'll come back and discuss some of the other stuff. So give me just a minute here, and let's get started. Let me make sure everything's working. Great. So tonight we're going to be talking about Texas law of contracts, as shown right here. What's going to happen here is, as you can see, we talk about these learning objectives. Each and every one of these are very important, and something that you'll become very familiar with is the Texas Real Estate Commission. The Texas Real Estate Commission is going to be one of those areas that is extremely important. They actually have a lot of duties that they play a part of. We're also going to be talking about unauthorized practice of law. One of the key things about unauthorized practice of law is that with law, what occurs is in this situation, when you are a real estate agent, there may be situations in time that, for example, in this situation, I come over here and Wyatt here we'll use, for example. Mr. Wyatt, he tells me, he says, you know, Mr. Nobles, I want you to help me find a lease. I have a current lease that I'm trying to get out of. And I need to know what my duties and ramifications and how I can get out of the lease and how I can break the lease and move into this new place. Pursuant to that, if I was to answer his question, I would technically be breaking the unauthorized practice of law provision right here. Because the fact is that when I'm going through in regards to unauthorized practice of law, I cannot give legal advice. My duty is I can explain forms, I can explain basic information, basic concepts, but I cannot tell you how to break the law, okay? Or how to break a lease. I can kind of read your lease. I can take Wyatt's lease and I can read through it and say, okay, well, Wyatt, it says if you pay $250, then in this situation, Wyatt, guess what? You can get out of your lease. But I cannot tell him court cases and things of that matter. And we'll go into that in a little bit. We're also going to talk, like it said, about the broker-lawyer committee. What exactly is this broker-lawyer committee? What is all entailing within this committee and what it does? We're also going to be talking about TREC's rules regarding the use of promulgated forms. There are certain forms that have been promulgated. When we're talking about promulgated, we're talking about standardized, okay? So in this situation, these are going to be standardized forms. We're also going to explain and give examples as to the exceptions to the TREC rules regarding the use of promulgated forms. We were going to also spend some time in regards to Section 8 or Section 5.008 of the Texas Property Code. And this is for sellers who provide a notice, basically in this situation, in regards to when they are selling their property. Just want to make sure nobody's sitting in the waiting room here. Okay. Again, one of the key things that we all want to be looking at is to identify the exceptions to the seller's disclosure notice. This is very key. And I'll give y'all some good examples on this when we get to that one. Of course, when you mess with the computer, it knocks off the stuff. Hold on here. There we go. And we're also going to explain when the seller has to provide their disclosure. And we'll also describe the buyer's rights based upon the receipt of that disclosure. Further, we'll describe how the Deceptive Trades Practices Act also applies to real estate agents. So as you can tell tonight, we will cover a lot of material, although you'll notice one of the things is this is what most of your slides are going to look like, okay? Most of your slides are relatively blank. They don't give a lot of information. So a lot of the stuff that you're going to get is going to be out of your textbook and out of the information I'm going to share with you this evening. So in this situation, this is where you get to start taking notes, all right? So the very first thing that we want to talk about before we even get into TREC and broker-lawyer committee and DTPA and all of this other stuff, we don't care about that stuff, okay? We really don't care about that. What we do care about is in regards to this initial statement right up here at the very top. It's called the Texas Real Estate License Act, often referred to as TRELA, okay? And this act is what actually ended up, it gave the contact and the information of how we're going to start regulating the real estate commission, okay? So their job, their duty in this situation is how are we actually going to go in and regulate the real estate field, okay? Now, you'll notice that TRELA is going to be administered, however, by TREC, okay? And that's very key here. TREC did not create TRELA. TRELA created TREC, okay? So very, very important in that situation. Also, rules regarding contracts. TRELA also came in and said, we're going to also state how we're going to be regulating the forms. Back in the day, and you can talk to many, many, many different brokers that have been in this field for 40, 50, 60 years, they'll tell you back in the early, probably 80s, 70s, and 80s, if you wanted to buy real estate, it was one legal sheet of paper that had the name of the parties, the property address, and then just a big blank spot. That was it. And then it had them sign the piece of paper, and that was basically all it was. Just one sheet of paper. That was all there was. Well, the problem with this in this situation is, guess what? You have certain notices and regulations, as you'll see, that we have to make certain that we're abiding to, okay, that we have to follow with. So as we go through this, we had to change up our contracts to make them where we met certain requirements that are stated by law. Now, one of the key things that we want to look at here, so you've got to have that understanding. And one thing before I jump into this, let me go back for just a second. I want to say something here. What I really would like you to do if you're taking notes tonight is I really would like you to write down TRELA or do Texas Real Estate License Act, whichever way you want to do it, but do TRELA and then draw an arrow down, TREC, and then draw an arrow down and put broker lawyer committee. Okay, so you have TRELA, arrow down, TREC, arrow down, broker lawyer committee. Okay, and the reason that we're doing that is because of this situation. It shows you kind of who created who, or who's over who. Okay, so TRELA is the head of everything. The Texas Real Estate Commission is underneath TRELA, but the Texas Real Estate Commission is over the broker lawyer committee. Okay, you need to remember that. That's going to be very key, and you'll see here in a little bit. Now, in regards to this slide, the unauthorized practice of law. Now, the key thing about the unauthorized practice of law is, of course, it is prohibited by TRELA. It is completely prohibited by TRELA. It is not acceptable. And so in this situation, what is occurring is that you cannot, no party can practice law just because they are a real estate agent. Not even if you're a real estate broker like me, who has been in this for over, 11 years now, going on 12 years. Okay. So in that situation is, even though I know the forms, I know the content, I know everything about how real estate works, I cannot practice law. I've seen and I've reviewed and seen deeds and restrictions and everything else, but ultimately in this situation is, I myself cannot draft those documents, nor can you as a real estate agent. So when you come in, your job is simply this. Your job is to simply go over and to end up practicing real estate, and that is to sell real estate. That's it, nothing else. Okay, your duty is to sell real estate and not another thing. Okay, now one of the key things is, let's say in this situation that Stefan goes over and he says to Wyatt, who's his client, says, oh, yeah, Wyatt, all you got to do is you just need a special warranty deed, and I can go Google that online, and I'll make you a special warranty deed. Well, if Stefan does that, what happens is Stefan's license can either be suspended or revoked. Okay, Stefan cannot, even though he may be in the field 50 years, Stefan cannot, in that situation, draft any type of documentation. It's against rules. You can get into a lot of trouble. And here's the best part. Okay, Stefan, you ready for this? Stefan, even though he does it, well, his license may be suspended or revoked, but here's the best part, Stefan. You end up, not only do you lose your license, but guess what? UPL is a criminal offense, and you can go to jail for it. Okay, so it's very, very key in this situation that you understand that your actions that you do, while you may lose your license here as suspended or revoked, guess what? You can't actually go along and go to jail for it. Okay, so this is a criminal matter. It's not just civil. Another thing that we'll be spending time with is going through the Realtor Code of Ethics. Now, if you are a licensed real estate agent or you have any familiarity with real estate, you will understand that in this situation is that we do have to go through and be very familiar with the Code of Ethics. Okay, and we will spend some time on this in one of the other classes, going into detail into the specifics. And when you get your license, you will spend an entire 4 hours with the association going through this. So you will know your code of ethics by the time you end up start practicing. The licensees may give factual statements in business details and explain the forms. But again, like I said, you may not give legal advice. Okay, you can go through and you can review the information. You can go through and you can end up giving all of the information that you know and explain the forms. I could give every one of you right now. I could say, all right, Wyatt and Linda and Eugene and Stefan and Keith and Darren and Garrett, here's all you a form. Okay, everybody, you got your forms, but y'all can read it, but that's all you can do is you can read it and explain it in that situation. You cannot interpret it. Okay, you cannot give legal advice in this situation. All you can do is go in and explain it in layman's terms to them. All right, so that's going to be something that we'll be talking about as we proceed, is that you can only give factual statements and business details. That's basically all you can do. You cannot go in and try to interpret. You cannot go in and go into a lot of detail. You can only say, well, Mr. Wyatt, if you look here on page 2, this basically says that, that the seller will pay for the title survey, and a title survey is blah. I can tell you that, but I can't tell you if you need to buy a title survey or not. Okay, I can't give you a lot of information. I can only end up giving you the basic information. Does that make sense so far to everybody? Okay. And again, like I said, if while I'm teaching you have any questions, there's the chat box. Shoot me a message. Again, I'd like y'all to send it through to everyone so that everybody can see it. But that gives me an opportunity because I know some of this may be over your head. Don't hesitate to ask me questions. That's what I'm here for. All right. Next question or next thing. So, Mr. White, I got a question for you, sir. All right, Mr. White, where does this broker lawyer committee, where does it fit in? Is it above track? Above track? Where's it at? At the bottom. Okay, they're at the very bottom. So in this situation, this committee is a committee that is dealt with basically, okay, it's underneath track. So its job is to draft, edit the forms, and TREC then must approve those forms and then promulgate them. And this is very, very key. You don't learn anything else from me. This is very, very key. TREC, you might want to write this down. TREC does not draft the forms. TREC does not draft the forms. And the broker lawyer committee does not promulgate the forms. I'll say that again. TREC does not draft the forms, and the broker lawyer committee does not promulgate those forms. Now, Miss Linda, got a question for you, ma'am. What is this word promulgate? What do you think that means, Miss Linda?
That means
standardizing them. That is correct. It means to standardize. It means to make those forms where they are now standard. Everyone must follow those forms. Okay. So in this situation, the broker lawyer committee will draft the forms. They then submit it to TREC, and TREC then reviews, approves, and promulgates. Okay. So in this situation, this is questions that might be asked of you. Is Mr. Eugene, sir, you are now TREC, and Miss Linda is the broker lawyer committee. Okay. Miss Linda submits to you, Mr. Eugene, to TREC a form. What happens, do you think, Mr. Eugene, if you get the form and you don't agree with it? You're TREC. What do you think happens? I know we haven't discussed about this, but what do you think happens if Miss Linda, the broker lawyer committee, submits it to you, TREC, to approve the form and you don't like it? What do you think would happen? It sends back. It's going to go back to the broker lawyer committee, and the broker lawyer committee will then go in, and the broker lawyer committee will make changes, and then they will send it back to TREC for approval again. TREC never, 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 if I'm trying to emphasize this here, TREC never drafts the form. Even if it's submitted by Miss Linda, who's broker lawyer, and it's one or two words, Mr. Eugene, who's TREC, is not going to just change those one or two forms. They're going to send it back to broker lawyer to do their job. Okay? Pretty simple so far. All right? Now, one of the key things, so that's a key thing I wanted to emphasize on. Another thing is very important. It's composed of, you're going to have to know this part right here. Those of you that are online and you're watching, you need to know the composed of. You need to circle that. You need to end up emphasizing that. You have to know that. Okay? And those of you that are online right now, just know, I want you to be aware that you do end up, you will, and those of you that are in the classroom tonight, you do have access to these slides. So you will have access to go through and make changes and everything, and you can print them off, and I do encourage printing them off before coming to class, okay, so that you can write on them and everything. But again, it composes of 6 licensed real estate brokers, 6 lawyers, and 1 member of the public. Now, Mr. Stefan, got a question for you, sir. Why in the world do you think we're going to have 1 member of the public? Why do we need this? This could be just an average Joe. It could be, say, Wyatt here. He could be this person. Why would we want Wyatt sitting in with people that are as knowledgeable as me and 6 lawyers?
Be the voice of someone that doesn't know about the system.
That's right. those of you that didn't hear this online, what he just said is Wyatt would be a voice of someone of basically that's not familiar with the system, does not know the everyday terminology. Because here's the thing, guess what happens, guys and gals? We end up, our job as real estate agents, we know our stuff. Just think about your industry where you work at. Whatever job you end up having, guess what ends up happening here? You end up, you're familiar. You know your terminology, okay? So, Mr. Wyatt, for example, you end up, you work in the restaurant industry. Is there certain terms or phrases that you say in your industry? Give me one, for example. Table what? Or sometimes you don't even say table, do you? Sometimes you say sit them at seat 4.
Yeah, we say like booths, regardless if it's a booth or not. That and just terms like short and abbreviated of the drinks.
Of the drinks? So you cut things down to make it quick and easy, right? Mm-hmm. You make it simple. But if I was to walk in, and I've never worked in your industry, Mr. White, ever in my life, mm-hmm. and I walk in and I'm sitting down and I'm like, what the heck is all this? I don't know what I'm going to do. I'm going to screw up the order. So the key thing is in this situation is you have to understand the key point of this that I try to tell everybody is that we have to bring in a member of the public to kind of not so much dumb down, but to bring it back down to layman's terms. Okay. When I first ended up, I had my office manager that I hired. She still tells me that, bring it down a little, bring it to me to understand, Justin. And the reason being is the fact of the matter is I'm just used to saying terms. That's just habit. I know how to say terms. So we have to sometimes bring some in so that they understand where you're at. Okay. For example, my dad, he works in the machining industry. He'll start talking about all these Hawashians and these couplings and all this. And I'm like, what the heck are you talking about? I have no damn idea what you're saying. But what happens in this situation is that I have to end up, he's got to bring it down. So the whole point here is that we have to bring it to the everyday person to understand. Now, understand also, they will on the test, on the licensing exam, they will ask you these questions that are up here. They will ask you how many people are in them. They will ask you basically how long they serve, how long is their term. And as you can see, these people, each one of these people staggers 6 years term. So once you're appointed, you're going to stay on it for 6 years. After 6 years, you're going to be removed. So they're staggered. So they will ask you those questions. Now, what's going to happen here, and we're going to spend not a lot of time here, but you're going to spend an entire class, which will be the next class after this one, that we're going to talk about promulgated forms, okay? And if you're familiar with any real estate, you've heard the 1 to 4 family residential resale contract, okay? That is the form, okay? The 1 to 4 family residential resale form, you will utilize 90% of the time, 90%. So you need to be very, very, very familiar with that form, okay? If you are not familiar with that form, what will end up happening is you're going to end up go through and you want to make certain that you do complete these in a way that's going to be understood, okay? So very important that you are familiar with these different terms. Now, again, you have to, and this is extremely important, cannot emphasize this enough on importance, it is extremely important that you utilize the most current version of the form, okay? And we'll talk about that here in just a minute. But you must utilize the most current version of the form. If you do not use the most current version of the form, what will end up happening in this situation is that you will turn into a situation that it can get a fine, okay? So one of the key things is, and this is kind of where I tell people this all the time, very, very, very important, okay? Very important here. Understand in this situation, we have to make certain that as we're going through these, that the form is the most up-to-date information. We have to make certain that what we're dealing with is that we are using the right form. And the brokerage that you sign with, you need to make certain that that broker actually utilizes a platform that updates these forms. If your broker is to, and they can do this in some situations, If your broker decides, well, we're just going to print off the stuff, okay, and we're just going to let our agents go onto Trek's website and just print off stuff. Well, the problem in this situation is that what's going to happen is if they just print off information, they're going to end up, you're going to have a little bit of an issue, okay, because they may not have the most current form. And if they don't have the most current form, what can occur and what can be of an issue is that you can end up having some confusion, okay? So again, we have to make certain that as we're going through these, that we stay up to date, that we're not being cheap when dealing with this. Again, you must also use unless, and there are a few exceptions here, okay? Each one of these we're going to talk about in regards to how these are utilized, but we also need to understand that there has to, in some situations, they can end up, there can be some matters in regards to what they're going to be used for and how they're going to be used, okay? So again, we do need to make certain of that. Please bear with me. I just got a text message from a student that's trying to get in. Give me just a second here. Give me just a second, please. Okay, Miss Linda, for a minute, can you call this student and explain how you step the other one through and how to join, please? That's the deal right there. If you could step out while I finish this up with them, please, I'd greatly appreciate that. Okay, so in this situation, the key thing that we need to make certain, I need to go back here, is as you'll see here, there are a few lists in regards to each one of these, okay? One of the key things that we need to make certain of is that we need to, number one, understand that we have to use the most current form unless, okay, and this is very, very key, unless the licensee is going to be the principal. Now you're probably like, what the heck is that? What are you talking about, licensee and principal? I'm confused. Well, here's an example here. Let me explain. When we talk about licensee, we're talking about an individual that is licensed, okay? A person that actually has a real estate license. Now, this person can be a real estate broker. This person can be a real estate agent, okay? But ultimately, if a agent is representing themselves, so Mr. Wyatt here, Mr. Wyatt says to me, he says, Mr. Nobles, I'm going to sell my own house. Well, if he is going to sell your own house, you don't need to use the promulgated forms. Do you understand me there? So if you're representing yourself in your own house or your own property, you don't need to use any of these forms. Does that make sense? So in this situation, if you represent yourself, you don't have to use any of the promulgated forms. If the federal government is going to be involved in it, and where this comes in is HUD, okay? HUD homes are ending up, these are ultimately going to require other forms, and so you would not use the promulgated forms, okay? So if you're representing a client that's buying a HUD home, then in this situation, the federal government will require a separate form, and because of this, what ends up happening is the current form does not have to be used, okay? Now, if the principal has provided and requires use of other contracts, if, for example, that I go, Mr. Wyatt, we're going to say you're a real estate agent right now, and Mr. Wyatt, you go back there to Mr. Eugene and you say, Mr. Eugene, I'm a real estate agent and I want to represent you in selling your house, and Mr. Eugene says, yeah, that's fine, Wyatt, but I want you to use this form that I made up. Guess what? You have to use that form. Okay. So if your client tells you what form to use, you have to use it. Now, a little side note, okay, or they'll call it sidebar often, In regards to a sidebar, what ends up happening in this one is you need to be very careful. Because Wyatt, if Mr. Nobles tells you that, you need to talk to your broker. Okay, you need to talk to your broker and tell your broker, say, hey, wait a minute here. My client is wanting to end up using his own form. Can I do this? You need to make certain that your broker is aware of this so that we make certain that all aspects are covered. Okay, we have to make certain that all aspects are covered. If we don't do this, what can end up happening is you can run into an issue. Okay. Now, again, even though it's an issue, it still is an exception, and that's very key. You need to know that. Number 4, no contract has been promulgated for a specific use, and licensee uses contracts prepared by an attorney or a broker-lawyer committee. There will be instances when you are working in real estate, I promise you this, where we're going to run into a situation that there's no contract that's been promulgated. Okay? There will be something that might come up, especially now with Bitcoin and all these different types of funding and all, that there may not be a particular clause that's in these contracts. If that is to occur, sidebar note for you, you need to go talk to your broker, number 1. Your broker needs to advise you in regards to what exactly you need to be doing. That's very, very important. But oftentimes your broker is going to have an attorney on retainer, or they're going to have a broker, or they're going to have access to contact the broker lawyer committee. But oftentimes, if it is a transaction, you're not going to have time to run it through the broker lawyer committee. You oftentimes hire an attorney. Okay, and your broker needs to know about that. All right, next one. The seller's disclosure is addressed in paragraph 7B of the 1 to 4 family. All right, hold on just a minute. I want to make sure I'm staying on task here. Yes, okay. The owner's disclosure requirements. Now, in this situation, seller's disclosure is going to be addressed in paragraph 7B of, and look at this right here, 1 to 4 family residential contract. Pretty interesting here, isn't it? Okay, so in this situation, what you need to make certain of is we need to make certain that when we're dealing with these things, that we have to provide, a seller is required to provide a notice to the parties, and it is going to be addressed, that notice will be addressed in regards to 7B of the 1 to 4 family. Now, the seller's disclosure is a requirement of the Texas Property Code, and there is a form that TREC has provided called OP, and the reason it says OP is for optional, okay? OPH is a way to provide the disclosure. Now, sellers can limit their future liability with full disclosure, okay? So in this situation, one of the key things that we need to make certain of is that while we're going through these different situations, we want to make certain that everybody understands these different processes, okay? So what ends up happening, and one of the key things that we need to make certain of, is you are going to have these different elements, okay? You will end up having these different elements that will be processed, but it is very, very important, like I tell people all the time, is that you must, as a real estate agent, we have to make certain that when we go through these situations, that we are going through, and we want to make certain that that we're telling our clients, okay, that we are telling them exactly the importance of this form, okay? And I'll explain why. Here's the biggest and most important part here. You ready? So in this situation, Mr. Grossman here, he ends up, I talk to Mr. Grossman to get his listing, and I say, Mr. Grossman, here is a form that I need you to complete. And he's going to see this form, and he's going to be like, well, you're my real estate agent, Mr. Nobles. You need to complete that form, okay? Well, here's the thing. Mr. Grossman, did I live in your house? Did I ever stay in your house? I probably just came into your house one time to just talk to you about listing your house. I don't know what's all been going on. I have no idea what you've been doing. I have no clue in regards to what all has been happening. I have no clue whatsoever. So in that situation, and this needs to be put down in bold words. I mean, if I could end up, I would tell you, write the whole booklet, just put, you never, okay, never, ever fill out the seller's disclosure for your client. Let me rephrase that one more time. You never complete the seller's disclosure for your client, period. Period. If you complete that form for your client, you have just opened yourself and your real estate broker up to liability. And not only just liability, but 3 times the amount of damages. Okay, so we're not talking small. So Wyatt, you go over there, you're a new agent, you got this, I'm going to play, always, Wyatt knows me. He knows how I like to play devil's advocate a lot. So Wyatt, here I am, I'm an 80-year-old man, barely can move, I'm walking on my walker, and I'm like, Wyatt, I just can't fill that form out. Can you fill it out for me? Why aren't you going to? But I'm an old, fragile man that can barely move. That's right. You put your broker and yourself in liability, and you can't do it. So here's the thing. Trek loves to test you with some crazy hypotheticals. They love it. They love to give you crazy stuff. And they'll make it feel very sympathetic. Mr. Eugene, your client, she just ended up, she just lost her husband, and she lost all her poor kids, and she's about to be homeless, and she really, really can't, she's hurting with arthritis, that if she writes, it's so hard. Don't you feel sorry enough to fill it out for her? Why not?
I don't want to get in trouble. I don't want to get my broker in trouble.
That's right. You don't want to do that. So they're going to give you these sad sob stories, but ultimately, no, it's not our job. Okay, we don't fill this out. If you fill it out, you get yourself into trouble. Yes, Miss Linda.
Okay, there's some people that actually not right.
Yes.
And they put an X there, their signature.
So let me say what you're saying so far. So everybody's listening online, Miss Linda said, there are people that cannot write, and they are literally, they have arthritis severely, and all they can do is barely, their hand is very limp, and they can just X. That's it. Okay, so go ahead, Miss Linda. What's your finish your question?
So they are interested in purchasing a home and all, so they cannot fill the form out. So what do you do in that situation?
So she's saying, what do we do in the situation if the person cannot fill it out? They want to sell their home, but they can't write. Good question. Very good question. The answer to that is number one, they need to have a power of attorney. And you as a real estate agent should be the one that needs to tell that client, if in this situation it was you, Miss Linda, I would say, Miss Linda, I am so sorry that you are ending up that you cannot write. I apologize. I know that's probably very difficult, but do you have somebody that that could end up, that could go over here and possibly, sign on your behalf as an agent? Now, of course, you need a power of attorney for that, but I can get you in contact with an attorney and they can help you draft those documents. Do you see kind of how that works? So even if, like you said, that's a very good question, even in the worst thing, you never. Now, I'll throw one in there. I'm going to throw one more thing in there, Miss Linda, into your deal. So Miss Linda tells me, well, okay, yeah, Mr. Nobles, I want you to be my power of attorney. What do you think here? Miss Linda wants me, her real estate agent, to be her power of attorney. Yes, you can. You can. But is it wise to do that? No. You can be a person's power of attorney, but it is not wise to become their power of attorney. Okay? It's different if it's your mom. And even in that situation, if it's your mom and dad and you're signing on their behalf, most attorneys would say that's fine. I still, as a broker, would say no. Even though if my parents told me, I want you to sign on my behalf, I still am not going to do it, just because of the fact is, if you're their agent, you cannot have any financial benefits as a power of attorney. Does that make sense? And in that situation, if I'm their agent, am I making money? Yes, I am. If I'm their agent. If I'm selling their house, I'm making money as commission. And as a power of attorney, you can't be making money. Does that make sense? So I could be appointed it, but not a wise idea. Makes sense. So in those situations, like I said, very good questions. Again, there is a form called the TREC form OPH. Again, OP stands for optional, okay? But it is OPH, and this is a way to provide it. However, you can provide any form you want. Everybody has their different forms. Texas Association of Realtors have their own form. But again, the key word on this, TREC form OPH, is the minimum amount of data you have to give somebody. Let me say that again. OPH, the minimum amount of information that you need to give. Okay. You'll notice if you look at TAR versus TREC form OPH, TAR form is going to be more in depth. OPH is going to be less in depth. Okay. But again, the only requirement is OPH. All right. And again, it depends upon your broker in regards to how detailed that they're willing to go. Now, in regards to the next question, okay. Now, paragraph 7B says that a buyer received the disclosure prior to signing. We're going to pull this up here. Actually, let me see if I can't pull it up. Give me just a second here. All right, so we're going to pull up TREC form here. Let me go. If you notice right here, I'm on TREC's website. This is TREC's website, by the way. This is where you will be signing up to take your test and everything. But if you come right down here to forms, you'll end up seeing, you can go right here to contracts. You can go right here to contracts and looky here. Here's all the forms. Right here is the 1 to 4 family residential resale, the one that we just talked about. We're going to go and pull this form up real quick. So we're going down to paragraph 7. We're going to roll on down here, and we're talking about right in this line right in here. Okay, we're talking about 7B, and you got B1 and B2. All right. Now, the key thing that I want to emphasize on this one in particular is this. Okay, is in regards to this aspect right here. If you ever in a situation you want to know when you have to give a seller's disclosure notice, all you got to do is go to the use Google Texas Property Code 5.008, and it'll tell you all the time that there needs to be the seller's disclosure needs to be given. Okay, so in that situation, what ends up happening is it gives you the in-depth analysis of that particular one. Okay, so in this particular situation, what occurs is if you want to know when a property code needs to be provided, you just go to Property Code 5.008, and you can see, when do I need to give the notice to my client? And one of your assignments that I want y'all to do this evening after we finish lecturing is I want you to end up actually Googling Texas Property Code 5.008 and read it. Okay? You may think, why do I need to do that? You will thank me when you get your real estate license. Okay? Because you will want to know this information. There are certain times that it's not required, and there are certain times that it is required. Okay? But again, this right here gives you that notice. Okay? Now, again, here's the key thing. If you are in real estate, and my office manager thankfully is sitting here tonight, and I'm ending up, I'm telling y'all, but I'm also telling her as well, one of the key things that's extremely important, you should, here we go again, you should never, 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 never have a contract signed without a seller's disclosure notice given. Okay? So let me give you a hypothetical. Mr. Eugene here, he calls me and he says, I want you to list my property. I say, okay, Mr. Eugene, sure. It's going to take me about 3 to 5 days to get everything taken care of, Mr. Nobles. But in this situation, sir, I need to go ahead and I'm going to put a sign in your front yard. Okay? I'm going to put the sign in the front yard, but I'll have it ready to be listed in 2 to 3 days. Okay? Mr. Nobles says, sure, perfect, go for it. Put a sign in the yard. Okay? Well, guess what? After I put a sign in the yard, Mr. Wyatt, who's a real estate agent, drives by and sees it and says, hey, I've got a client that wants to put an offer in right now, right this minute. Really? He says, I need that. I want to do it right now. We want to submit one. So my question is, Mr. Stefan, here's our hypothetical here. What has ended up happening, Mr. Stefan, is this. Mr. Noble's property is not on the MLS yet. It's not really listed yet. I just put a sign in the yard. Mr. Wyatt has shown up, has a client that's interested, and has submitted me a contract for exactly what Mr. Nobles is wanting. But I don't have a seller's disclosure notice from Mr. Nobles. What should I do, Mr. Stefan?
Reject the offer.
No, you never reject an offer. What do you think, Miss Linda?
What I would do is I would get my, personal phone and get a seller's disclosure signed and filled out ASAP and buy it for time, and then come back to Mr. White and say, okay, we can talk now, basically.
All right, those of you that were online, what she said what she would end up doing is she would end up in this particular situation. She would call Mr. Nobles, tell Mr. Nobles, of course, give him the contract, because you legally have to give him the contract that Wyatt gave you. You can't hide it. You can't hold it. Give Mr. Nobles the contract, but tell Mr. Nobles, here is the seller's disclosure, and I need you to complete that seller's disclosure prior to us accepting the offer. And what I also want you to do is where Mr. has checked box 2, which is on here, y'all, on your screen, box 2, they need to mark that out, check box 1, and then next to it, because you've given them the seller's disclosure. Now, I'll explain why that's such a major thing, why that's very, very important. You ready? Here we go. Why it's extremely important is, Mr. Wyatt, I want all of you real quick for just a second. Everybody should be able to read. I want you to reach paragraph 2. Mr. Wyatt, for those of you that are in class, Mr. Wyatt's going to read it out loud. Come on up here. You're going to stand up here and read it. Come on and read it to everybody else. And online, I want you to read it on your computer what paragraph 2 says. Go for it, Mr. Wyatt.
Buyer has not received the notice within blank days after the effective date. The buyer may terminate the contract at any time prior to closing it, and earnest money will be required.
You skipped a line.
Where?
You put
Closing
date of this, that's
Closing and earned money, right, will be refunded to buyer, and if seller delivers to the notice, buyer may terminate the contract for any reason within 7 days after a buyer receives the notice or prior to the closing, whichever first occurs, and the earnest money will be refunded to the buyer.
there you go, great job.
Good job.
You got it.
Okay?
Okay.
Good job. So he's just read it, and those of you online should have had enough time to read it. And what it basically says, here's the key thing. Read right here. What's this say, Miss Linda?
Buyer may terminate
This contract for any reason within 7 days after the buyer receives the notice. So in this situation, if Mr. Eugene ended up that I'm going to go and sign this paper and accept it without the seller's disclosure, guess what happened? Mr. Eugene, you just gave them 7 more days to pull out of this contract for any reason. 7 more days. So in this situation is you're giving them a free option period for any reason from when they receive the notice. So a lot of times when I'm writing a contract, guess what I purposely do? If I want to have a free time to get out for any reason, I'll put 10, 15, 20 days in there. Because what does that say? If I put 20 days in here, Wyatt, when do I have to get you the seller's disclosure? Within 20 days. But what does this say down here? Once I deliver the notice, that 20th day, how many more days can you back out of the contract? 7 more. And most contracts end within 30 days. So you're almost going straight up to closing where you can do what? Back out of the contract for any reason, get your earnest money back. Do you see how when I write my contracts, I look at all these little things? Because the fact is, all of this information is in my favor. If I'm on the buyer side, I want as many days in this blank as possible. If I'm on the seller side, I don't want this to even be checked. I want box 1. Do you see how this works? Very, very important. Okay. All right. So let's go back to our PowerPoint. And as you can see, this sums up what I just said. Sums up exactly what I said. 7B1 says the buyer receives the disclosure prior to signing the contract. And 7B2 says that the buyer will receive the disclosure after signing the contract and gives the buyer the right to terminate for 7 days after receiving it. That's a problem. Okay. So again, this is your favorite part if you're a buyer's agent. It's the best thing in the world. It's a free option period. I even have sometimes where a client will go in and they'll say, well, I don't really want to have an option period. Okay, we'll just do this. We'll mark box 2, they don't have a seller's disclosure, and we'll just put pressure on them to sign it. Once they sign it, you don't have to pay for anything because you get whatever days plus that. So if there's 5 days plus 7, you got 12 days you can bag out for any reason. Y'all see how this works? Okay, so very, very key here. Now you'll see right here on 7B3, okay, on the contract. 7B3, if you do what I'm telling you and you're reading the assignment tonight and you read, what was that section again? Section 5.008, 8 will end up, if you read that, it gives you right here, the exceptions to the rule. Okay? So in this situation is if anything under bullet 2, any of these that we're about to go through, if these apply to it, then you would check box 7B3. Okay? Everybody should be on the same page with me. All right? So what we're about to say, what I'm about to cover, if any of these are in here, bullet 2, then you're checking 7B3, which basically says sellers do not have to give a seller's disclosure. So let me re-emphasize this. I want to emphasize this a lot. I want to make certain that y'all understand that 7B3, if any of these 11 exemptions are part of your transaction, you do not give a seller's disclosure. But if you have a transaction that's not in these 11, guess what happens? A disclosure is required. Does that make sense? So if it's not one of these 11, it's required. You have to give a disclosure. No buts. Makes sense. Good? Okay?
So you're saying if it's a new home sale or new build, you do not have to give them.
We're going to first go through these 11, and if that one's not on here, then in that situation, a seller's disclosure is not required.
Are those 4 part of the 11?
This is some of them, yes. Okay? Now, Ms. Nobles just asked a question. She says, so if it's a new home sale, I don't have to give a seller's disclosure? Mr. Grossman, what does it say up here?
It says
That doesn't need a seller's disclosure?
new home sales don't need it.
That don't need a seller's disclosure.
It would be the builders that were selling it anyway.
Well, here's the thing. Has a new home ever been lived in?
No.
So how would there be anybody to say anything? Okay. So the 11 that you have to be aware of. Number 1, if it's a sale by court order, Mr. Wyatt here doesn't pay his taxes. Mr. Wyatt fails to pay his taxes. They come and take his house and sell his house at a tax sale. Miss Linda, is there a order that's required? Is there a notice, disclosure that needs to be given?
I would say yes.
Mr. Wyatt, do you need to give one? No, because it's an exemption.
No, it's an exemption.
Okay. So Mr. Wyatt, because his house is sold, even though it's a resale house, Mr. Wyatt's house was sold by court order. Here's the reason why. You ready? Mr. Wyatt, if they take your house, are you still going to be around to complete a seller's disclosure? No, you're going to be gone. How can I get it from you? Okay. So this is exempt. Okay. A deed in lieu of foreclosure. Okay. So Mr. Grossman ends up can't pay his mortgage. Because Mr. Grossman can't pay his mortgage here, he signs a deed in lieu. He basically signs over his right to Mr. Eugene back here, the bank, and says, I can't continue to pay you, sir. I'm transferring title to you. I can't afford it. Okay? Well, Mr. Eugene, did you ever live in the house if you're the bank? So do you know anything about it? Nope. And Mr. Grossman, are you going to be anywhere around when this house gets sold at auction? No. So we can't have a seller's disclosure. Miss Linda, you decide to go buy a brand new house. Brand new. built from the ground up. Will you get a seller's disclosure notice from me, the builder? No, because has anybody lived in that house? No, there's nobody to go to. Last one. What happens if, Miss Linda, you sell your house to your husband, Mr. Eugene? Do you have to do you give seller's disclosure? Do you have to give seller's disclosure? No, because why? It's a sale from spouse to spouse. You and him most likely lived in the property together. You already know, it's already considered that you would know what's wrong with the property. There's no seller's disclosure needed.
Why would you ever need to sell
in a divorce?
Oh.
Parties are divorcing. Your mom, dad, they lived in the main home. They're selling it to either or. They know what was wrong with the family home. Make sense? Okay.
So,
Yes, Miss Nobles?
what if, for example, if they were married
Okay.
and
What if they are married and
their job is a truck driver and they're always gone, and then she's there and not ever at home?
so one's a truck driver and one is a stay-at-home mom,
Yeah,
and the truck driver never sees the house, you're saying, because they're always gone.
right.
Does not matter. Still a sale from the spouse to the spouse, because in Texas, you're considered one. No matter what, you're one. So because of that, even though if your husband is nowhere around and he's never been in the house and never seen it, it's still a spouse to a spouse. There's no seller's disclosure.
And for instance, if you have a new bill,
Mhm.
you went through the whole process, you have been approved and everything, and then all of a sudden when the closing time comes up, your client says, I don't want this thing, and walks away. Will you still, and they said, okay.
So I'm going to sum up her question for those of you online. Miss Linda is asking, she said, well, what happens if a new build's being built by Miss Linda, and Miss Linda, like a day or two before closing, goes over and decides that, you know what, I don't want to buy the house. I'm walking away from it. Do I need a seller's disclosure when I go and sell it to now the builder? I'm the builder, and now she about walked away and I sell it to Wyatt. Do I need a seller's disclosure? What do y'all think? What's the consensus in here? What does that word right there say? Did you ever live in that house, Miss Nobles? No, because you never lived in that house. It is still classified as a new home. So there is no seller's disclosure. Okay, these are good questions. All right, very good questions. I mean, that's what I'm here for, is to answer these questions for y'all. All right, now what about the sale of real property, where the value of the dwelling does not exceed 5% of the value of the property? This one I love. This is always my favorite, right here. The sale of real property where the value of the dwelling does not exceed 5% of the value of the property. Guess what this means? You ready? This is Stefan's house. Y'all ready? Here it is. This is Stefan's house right here. You'll see it. Those of you that are online, you would see I've got like an old building here, really old. It's dilapidated. Okay. In that situation, if Stefan's house that he lives in is actually ending up, it's an old home that's basically caving in, and the value of that house does not exceed 5% of the value of the property, you don't need a seller's disclosure. Why? Because, Stefan, if you're living in a 1800s building that is almost about to fall in, do we really care about what is wrong with the sink or the toilet or any of that stuff?
More than likely, they're going to tear it down and build something else.
That's right. They're going to tear it down and they're going to destroy it. So there's no need for a seller's disclosure. Miss Linda.
What if it's a historical home and nobody claims the thing?
In that situation, she's saying, what if it's an historical home and nobody claims it? Then it will revert back to the state. And we'll talk about that when you were in another class. But it would revert back to the state. Okay? Look at number, whatever, I think 7 this one is. Sale to or from government agencies. If you're selling to any government or you're buying from the government, you don't need a seller's disclosure, because why? The government's going to do what? The government's going to sell it anyway. Okay? If there's a sell by trustee in a bankruptcy, if your property is sold at a bankruptcy, you just got to ask yourself these questions. Okay, you just got to think of these things. Do any of these actually allow for the person to go and write one up? No, the seller is probably long gone if they're in a bankruptcy or if they're selling it from here. These people are long gone. You can't get a hold to them. So you can't do a seller's disclosure. Just like the REO. You see REO. Most of you are like, what the heck's an REO? It's a bank repossessed home. That's what it is. The bank repossessed home. We just use the term REO. Repossessed. Okay. That's why I always tell people, think of it as repossessed. Okay. Bank has came back, taken the house. Again, is the owner going to be anywhere around? No, the owner's long gone. Owner is long gone. Okay. Now, this one's very interesting. Right here, the next one. Co-owner to co-owner. All right. So Mr. Eugene and me and Stephen and Wyatt and Miss Linda, we all own a company together. Okay. And we decide that we own 123 Main Street. Okay. We own 123 Main Street. And we decide, guess what? We're going to sell 123 Main Street. And we're going to sell it to Mr. Wyatt's restaurant that he owns. Okay. Well, in that situation, would any of us need to provide Wyatt a seller's disclosure? Why? He's a co-owner. He's co-owner. He's been in the building. He should know it. He hasn't. One of the co-owners is aware of it. Okay. So, in that situation, if you're a co-owner, guess what? You don't need to end up selling it. Okay. You are given a seller's disclosure. The sale between divorcing spouses. If they go in and in this situation, Stephen and his wife break up and he goes over and he's selling it. Again, it goes back to the same situation. It is a divorcing spouse. They don't have to end up doing a seller's disclosure. And if it's a sale by will, by an executor, guardianship, or trust, there is none. Because why? If we're dealing with a will, they're dead. They're gone. How are they going to fill one out? Okay. So again, these are some of those situations that you need to be aware of. Okay. These are just some of the matters that you need to have. Now, Mr. Grossman, come back to you for a minute. A client decides that they want to sell their 1 acre lot of land. Do they need a seller's disclosure? How many of you say yes in here? They want to sell 1 acre lot of land.
No, they wouldn't. There's no property to disclose on.
Okay, so I have a no. No. Miss Linda?
I'm gonna go no.
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 You're all wrong.
I was gonna go to yes.
You're all wrong. The answer is yes. Did you see anywhere? Let's go back here a minute. Let's go through these. Any of those talk about being exempt? 1 acre lot? Do any of those? Do any of these? No. So even though it's a raw land that's unimproved, okay, we'll say for example here, Darren, he decides that he wants to sell his 1 acre plat of land to Stephen in here, who he knows nothing of. He has to still give a seller's disclosure. Now, here's the best part, Darren, because I know you're listening in. Darren goes over and he tells me, he says, but Justin, come on, man. Really? There's nothing there. It's wooded. It's got nothing. I haven't even done nothing with it. You're going to make me fill out a freaking form to say what's wrong with it. There's nothing on it. Yes, you have to complete the form, although 90% of it is going to be unknown, unknown. You still have to complete it. Okay. Now, Darren, if you were to sell that property to your wife, then now what happens? Does he need to end up selling it? No, because if we go back here for a second, what did we just say? Down at the bottom, sale from spouse to spouse does not need it. But if you're selling it to a third party, you have to give it, even though you're going to put unknown. Okay.
You have to make sure that sometimes people spill stuff on.
That's correct. Miss Linda said, well, that's because the fact is that there's a spill on it or there's environmental hazards or things like that. It needs to be disclosed. And there's a reason for it. Okay. But again, these are your 11 exemptions. Okay. I know a lot of you are getting tired already. All right. But you can go ahead. But understand in that situation that you have to end up that you need to go ahead in this situation. You need to be aware of these. Okay. Now, I think I'm running out. Yes, I am. Haha. We'll come back in just a second. All right. Now, under the DTPA, this is extremely important. Extremely important. This is one of my favorite areas that I love to take time on. Is this one. Okay. And the reason I like to take time on this one is because the fact is it is very important. Very important. Okay. The DTPA, which is often what we're going to utilize, Deceptive Trades Practices Act, does not apply just to real estate. It applies to basically a lot of different things, and it's called the laundry list. So, for example, say that I go over and I hire a tree company, okay, to go over and to cut some trees for me. All right. And in this situation, when I contact the tree company, they go over and they start making these accusations, or not accusations, but this basically experience, okay, of saying, for example, a person goes on to, or this company goes on to Google and writes a bunch of fake reviews about themselves. Okay. So in this particular situation, what happens is because of my reliance on that review, I am basically taking advantage of the customer's lack of knowledge because I think I'm relying on other people. And if the job is done grossly unfair, then what can happen is I can sue that individual for 3 times the actual damages that I incur. So say, for example, that Wyatt here, he is a real estate agent, and Wyatt goes out and he's like, well, I need to go over and I'm going to go and I need to make myself look good. Okay. So Wyatt goes over and Wyatt goes online and he himself and his buddies go write a ton of reviews. So Wyatt goes about 50 people that he knows, has them all writing reviews about how wonderful he is, how great he is as a real estate agent. He's experienced and all of this stuff under, if you see right here, misleading the public. He does all of that, and I hire Wyatt because I relied on his reviews, and Wyatt ends up cost me, say, $50,000 in damage, okay, because he didn't know what he was doing. Now, what happens is I could turn around and I could sue Wyatt for not only my $50,000, but 3 times the amount because it's a punishment for you for misleading me.
And that's only if I mislead you?
If you make a false misleading, or deceptive act.
Gotcha.
Yes, Mr. Grossman.
And that is to protect the public, not the company or the agent.
That is correct. It is only the general public. It does not protect the broker. And the best part, that if you're the consumer, not the agent or the broker, is you can go after sometimes both the broker and the agent. So Mr. Wyatt here goes out, and he's sponsored by Mr. Nobles here, and he goes and does this without the broker's knowledge. Mr. Wyatt can not only get himself in trouble, but he can get his broker into trouble. Okay? That's why it is important, extremely important, that you are working with your broker, because if you're doing acts that are false, misleading, or deceptive, you can get sued up to 3 times actual damages. Okay? 3 times actual damages. And as it says here on the screen, a licensee, and if you see here, that's where what Stefan was mentioning, it's the licensee, not the consumer, a licensee taking advantage of the consumer's lack of knowledge, ability, experience, or capacity to a, and this is the key part right here, grossly unfair degree, and that is referred to, and this is very, very key right here, it's called an unconscionable act. Now, for an unconscionable act to occur, it has to shock the court, okay? So if Wyatt goes over and he has a listing that he's putting on, and he's like, this is the most beautiful house that you'll ever see in your entire life, okay? Now, my question, if Wyatt, you put that, this is the most beautiful house that you'll ever see in your entire life, Mr. Wyatt, does that shock you when you say that word? If you were to read that?
I'd be pretty shocked to hear that that's the most beautiful house.
But would it really shock you legally? Miss Linda, would it shock you if somebody says this is the most beautiful house in the world?
Yeah,
It would shock you?
in a way.
Legally.
Legally,
Mhm.
no.
Mr. Eugene? Mr. Grossman?
It's just an opinion.
It's just an opinion. Because what do they always say? Beauty is in the eye of the beholder. What you may think is beautiful, Wyatt, may be the most ugliest thing I've ever seen in my life. Okay? So in that situation that's an opinion. What is unconscionable is if Wyatt goes over and he gets, like I said, 50 people to write reviews about how wonderful he is in selling real estate, and he's never had represented any of those 50 people, that would shock the court. Because in that situation is if I was a normal person and I saw 50 reviews about how wonderful Wyatt is as a real estate agent and they're all fraudulent, I would be shocked. Okay? So when we talk about this, the key thing is it has to be grossly unfair degree, which is an unconscionable act. And that is referred to as it shocks the court. Does that make sense? Now, I'm going to pull one more thing up. And I'm going to give me just a second and bear with me here. We're almost done, ladies and gentlemen. No, wrong one. Let's see if I can find you a good one here. So here is what's called the laundry list, as you can see here. Okay, these are acts that are classified as items that can get you sued under the DTPA. Okay, if you're passing off goods or services as those of another. If you've ever been in any college before, what's this called? Okay, but what's the other word? Come on, Wyatt, you know it.
Yeah, I know the word of it.
Starts with a P.
I heard it a lot, yeah.
Plagiarism.
I know what it was.
Plagiarism is this. Wyatt writes a paper that takes him, say, for example, Wyatt goes over and he wrote this paper and did a lot of research and spent 6 hours drafting it. And then Justin goes over and takes it and passes it off as mine. That is plagiarism. But guess what? Plagiarism gets to haunt you in court because you can end up at DTPA. You have passed off the goods or services as those of another. Okay? And in that situation, you can be sued up to 3 times actual damages. If you cause confusion or misunderstanding as to the source, sponsorship, approval, or certification of goods or services, that's also DTPA. So if in a situation, Mr. Stefan goes back there and he says he wants to start Grossman's Realty Group, but he's sponsored by Noble's Realty Group, guess what? If he does not put Noble's Realty Group on his marketing, is Mr. Stefan causing confusion as to the sponsorship of the service? Yes, DTPA. Okay. If you cause confusion or misunderstanding as to the affiliation, connection, or association, or certification by another, is another way. If you are using deceptive representatives or designations of geographical origin in connection with your goods or services, if you're representing goods or services that claim to have sponsorship, approval, characteristics, ingredients, uses, benefits, or quantities, but do not, or a person claiming to have sponsorship, approval, status, affiliation, or connection, and does not. These are another method of how you can be sued under DTPA. If you're representing that the goods are original or new, if they are deteriorated, reconditioned, reclaimed, used, or secondhand. This one's very key. I'd like to spend a minute on this one. I'm seeing this happen a lot now as being on the board of directors. I'm seeing this in some of the issues. So Miss Linda goes out and buys a house, an older home. And Miss Linda goes and buys this older home, and she goes in and she guts it. I mean, takes it down to the studs. And she goes and she rebuilds the interior. Okay, she gut it all down to the studs and rebuild it. Miss Linda puts on there that it's a new home. Why? Is she violating anything? Yeah. Is she? Really? Why is she violating something here?
Because you're saying it's a new home. It's not like you're just
right. It's not really new. It's reconditioned. Okay. So in that situation, if Miss Linda was to sell it, and this is a huge argument that has been argued a lot, it still's being argued, but in that situation, Miss Linda may say it's new because I had to go in and redo it all. But in regards to it is the brick's still the brick, the roof's still the roof, even if she puts the roof. But here's the thing, doesn't matter about any of that. Mr. Grossman, were those studs replaced? Are they brand new? If there's one part of it that is not brand new, it is not a new home. Same thing goes down to if you buy a cell phone and you open the box. And once you open the box and you're like, nope, don't want this, I'm selling it. And I'm going to sell it as new. Is it really new? No, it's not. It has been resold. So if you were to sell something like that as new, you actually can end up getting yourself into a lot of trouble and be sued for 3 times damages. Okay?
So if they will have to, instead of that being or new, you're saying that they would have to basically dig up the slab and everything.
They'd have to destroy the whole house. Her question is, how do you redo it? For them to reclassify it as new, they have to tear everything down to not even the studs. They have to tear it all the way to the ground. They can leave the slab. The original foundation can stay because that doesn't do anything. But they have to tear it down to the ground. Okay? They can leave, and most of the time what they'll do is they'll leave the foundation and they'll just build around it or redo it and then report. Yeah. But it's still, that at that point, it's a new house because you're redoing it. Okay? If you're representing that goods or services are of a particular standard, quality, or grade, or that the goods are of a particular style or model, if they are of another, can also be a reason. This is my favorite one right here. If you make disparaging the goods, services, or business of another by false or misleading representation of fact. Very key. When you get out here and you start working in real estate, okay, I'm going to tell you, and I'm just telling you this from experience just because I'm an independent firm and a lot of people, they do this. Now, of course, I'm not petty and I don't sue for every little thing. But if you make disparaging remarks about another business that is false or misleading, you can be sued under DTPA. So if I go over and I am a franchised company, and I'm an owner of a franchise company, and Miss Linda is an owner of an independent firm. And Mr. Wyatt comes into my office, and Mr. Wyatt says, you know, he's interviewing for as an agent with me, and I'm sitting here and I'm talking to him, and he's like, yeah, but I'm thinking about going and working with Linda's Realty Group, and I'm a franchise company. And I'm like, you don't want to work with them SOBs. They are sorry, terrible people. They don't ever sell, and anything they sell goes to a lawsuit. You don't want to work for them because they're just crap. Did I make disparaging remarks? Yes, I have. Now, the key thing is again, you have to have this in what? Writing or recorded. Okay? You cannot just be Wyatt heard it and let's go. It needs to be somehow copied somewhere. Okay? But again, false, it has to be false or misleading representation. Okay? Very key here. And that's not just about services. Guess what? You as real estate agents, when you get your license, Wyatt, you're a real estate agent. You hate Stefan. You hate his guts. Everybody you go talk to for listings, you go talk to Mr. Eugene back here to get his property. And Mr. Eugene says, well, I just spoke to Mr. Grossman. And you're like, oh, that piece of you know what? You don't want to freaking hire that piece of you. He's such a dumb you know what, blah, 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 blah. Guess what? You just disparaged a business because you're independent contractors. Mr. Wyatt, you now can be sued by Mr. Grossman and 3 times the damages. And if he lost that listing, you got to pay him his commission times 3. Okay? So you have to watch what you say about other people, period. That's why I don't get myself into that kind of stuff. That's childish material. I don't have time for that. Advertising goods or services with the intent not to sell them as advertised. This is extremely important. So in this situation, let me see, who do I got on here tonight? Mr. Garrett here. Mr. Garrett, he goes over here, and Mr. Garrett goes over, and he says, you know what? I want to be the top producer in Mr. Nobles' business. I want to be the top producer, and I need to get leads. And Mr. Noble says I need to get leads. So here's what I'm going to do. I'm going to go over, and I'm going to talk to my mom and dad and my aunt and uncle and my grandparents and everybody else. And I'm going to go over there and I'm going to take signs for sale signs and put them in my family's yard. And I'm going to list them on the MLS, but my parents and grandparents and aunts and uncles aren't actually going to sell. They're just putting them there so I can get buyers to call. Well, guess what? Mr. Garrett, you just violated number 9. Advertising goods or services with the intent not to sell them as advertised. You cannot put a sign in the yard and say that my parents will sell their house or my family will sell their houses in the goal of just getting leads. Now, what is a way around this? Okay, a way around this is this. Is if your parents say, Garrett, in this situation, your parents say, you know, Garrett, sure, put a sign in the yard. We want $400,000 and our house is appraised at $350,000. If the parents would really actually sell it at $400,000 and actually sell at $400,000, then you're not breaking the law. Does that make sense? But here's the thing, and this is very important. If somebody does come in with a $400,000 offer and everything that you asked for, your parent can't turn it down. So if they call your bluff, you got to be willing to go. Now, another person had told me, well, I know what I'll do, Mr. Nobles. I'll go and put a sign out in front of my parents' house and list it for $1 million, and it's only worth $250,000. Now you're getting into a point where you're doing what's called a bait and switch. You have done an unconscionable act, because would a normal person react to that? No. So in that situation you have to be very careful when you're putting signs out. That's why when I talk to some of you and you take listings, your client comes in, Your client tells you, I want to list my mobile home for $800,000. Okay. That's fine. That's fine for you to list it. But it better have enough land or whatever around it to try to justify it. If it can't justify it, you may end up being in breach of number 9. Okay. So very key in regards to these situations. You have to make certain that you understand these. When advertising goods or services with the intent not to supply a reasonable, expected, or expectable public demand, unless the advertisement disclosed a limitation on quality. Number 10 often applies, and it does happen in real estate, but it often applies in this situation. Wyatt goes out and he says, for Black Friday only, I will list your house for $500. Okay? Sounds like a great deal, right, Wyatt?
Yeah.
All right. $500. I'll list your house. Mr. Eugene, what are you going to do? You saw that.
List my house for $500.
Yeah, he'll list it for $500. That's all he's going to take commission from you.
Oh, commission.
Yeah, that's all you got to pay.
I got a big enough house, yeah, but if not.
Well, if it's normally 3% you're paying,
Yeah,
that's $3,000 for every $100,000.
that'd be a good deal.
That's a steal, ain't it? So you come into Mr. Wyatt and you say, hey, Mr. Wyatt, I want to sign. I want you to list my property. And Wyatt tells you, Mr. Eugene, yeah, we just had somebody sign for that, and that was a one-time deal. So yours is 6%.
Well,
That's right. That's called a bait and switch. Okay? You cannot, in that situation, go in to use that type of market, and then they come in and you switch it on them. And it applies not just to real estate. If you ever seen any Black Friday deals, what happens? You go in, you're ready to buy, and they're like, oh, well, we only had 4 of those, and we're out. But we have this other one at $6,000. That is, in that situation, that turns into a bait and switch. Now, if Wyatt, in his situation, put a limitation of it, if in your deal it said, I'll list your house for $500, but only for the first 25 customers, then you're legal. You followed this rule. But if you don't do that, what happens in this situation is you can be a bait and switch, and you can be sued for 3 times actual damages. Okay? Making false or misleading statements of the fact concerning the reasons for the existence or the amount of price reductions. Look at this one here, Mr. Grossman. Making false or misleading statements of fact concerning the reasons for existence of or the amount of price reduction. So, Mr. Grossman, you have a client, we'll say, and your client wants you to drop the price by $25,000. I call you, Mr. Grossman, and I say, why in the world did you drop it $25,000? Well, you see, my client was going to end up, they were going to sell the house, but then they dropped it, but they're going to probably put the price back up because they're going to put new carpet in the house. And, you know, and if we really put the new carpet, we're going to take it off the market. So we're really wanting you to hurry up and put offers in. But none of that's true. Well, guess what? You made misleading and false statements. You can end up getting into trouble. Do you see what I'm saying? So, for example, another one kind of give you. Mr. Grossman goes over. Let's give this one. This will be a little bit better. Mr. Grossman, you're listing Miss Linda's property here. Okay? And Miss Linda finds out there are termites in her house. Now, you had it listed for $300,000. Miss Linda goes over, finds out that it's basically she's got termites, and it's pretty severe. It's pretty severe. Her house needs to be torn down. So you drop it from $300 to $250. So Wyatt calls you. He's like, dang, this is a good deal. Wyatt calls you, says, all right, well, what's the reason here, Mr. Grossman, for the drop? Mr. Grossman says, well, you know, she's wanting to move, and, you know, she's needing to get out of the house, and, you know, she just needs to get out of there and move on. Now, Mr. Grossman, did you violate anything? Yeah. You didn't tell the truth. You misled them. Guess what? If they buy that house and they have to tear the house down, it's a $300,000 house. Miss Linda and you and your broker probably have to pay $900,000. That's right. That's right. So in those situations, that's right. That's correct. If they don't notice, then they basically are now up a creek without a paddle, and that person could be killed or whatever. But again, misleading. You can't mislead, okay? Representing that an agreement confers or involves rights, remedies, or obligations which it does not have or involve in which is prohibited by law, okay? I go over and I tell you, Mr. Wyatt, I'm the broker, and I'm like, oh yeah, Mr. Wyatt, you want to buy this property? Yeah, Mr. Jacobs' property here, it conveys mineral rights with it. Here you go. And he signs the contract, thinking that he's getting mineral rights. When I clear as day know that Mr. Jacob told me that it does not convey mineral rights. Guess what? I have breached my contract here. Okay? Knowingly making false or misleading statements of facts are concerning the needs for parts, replacement, or repair service. This is for not only just real estate, but this is for y'all that get the cars. Mr. Eugene goes over, takes his truck down to Chevy Company dealership, and they come out and say, Mr. Eugene, sir, looking at this, I mean, you got to have a new transmission, a new engine, new brake system. I mean, you basically need all of these things. So Mr. Eugene goes and gets them all done, and guess what? He finds out that it was a false statement and they didn't need those parts. You can sue them under DTPA. Okay? Representing the authority of a salesperson, representative, or agent to negotiate the final terms of a consumer transaction. This one's very important because this is on y'all right here. This one right here. Okay? Salesperson, that's what you are. Or an agent to negotiate the final terms. If you misrepresent your responsibility, if Miss Linda goes in, she gets on the phone and she says, yes, my name's Linda Nobles and I'm a real estate agent and I am representing Wyatt today. Guess what? If there's no documentation that she is your representative, Wyatt, she has breached the law, and whatever damages she calls for you, you can sue her for 3 times the actual damages. Okay? Y'all see kind of how there's a lot of things in here that you want to be aware of.
Yeah.
A lot of stuff in here. We're going to stop here in a minute because y'all are going to finish going through these later. But
I'm sure there's like 50 or more.
no, there's about 24, I believe. And we're almost a little bit half past it. Okay. Basing a charge of the repair of any item in whole or in part on the quantity or warranty instead of the value of the actual repairs made to work to be performed on the item without stating separately the charges of work. So if you end up, you charge for repairs of an item in whole or in part on the quantity or warranty instead of the value of it, you can end up having a breach. And these are for property items. It may sound like automotive situations, but also houses have warranties. Okay. Disconnecting. This one's the key one right here. Okay. Disconnecting, turning back, or resetting the odometer of a motor vehicle as to reduce the number of miles indicated on the odometer gauge can end up getting you into trouble. Advertising of any sale by fraudulently representing that a person is going out of business. Very important here. If you utilize a situation that you're ending up as a real estate agent, you're like, well, shoot, I'm not getting any clients. My clients aren't coming. I'm not getting anybody. So what I end up doing is I go over here and I say, you know what? I'm going to advertise that I'm going out of business so I can get business. And then once I get the business, I want to reopen. you can be sued. Okay? You can't be doing that. You have to be honest. Advertising, selling, or distributing a card which purports to be a prescription drug identification card issued under section blah, blah, blah in accordance with these rules. Again, sometimes what will happen, and y'all will see this as you get your real estate license, some of these real estate agents will partner with prescription companies and say, if you utilize us, we can get you these prescription discount cards if you use us. If it is a bait and switch, it can come back and bite you. Okay? Very important. Any type of employing of a chain referral sales plan, okay, to sell your goods or anything can get you into trouble. Representing that a guarantee or warranty confers or involves the rights of remedies that have not been involved can also be in it. Promoting a pyramid promotional scheme. All of these are different things that you can have. You may say, well, these don't apply to me. Yes, you'll see in real estate, a lot of this stuff kind of comes together. Okay? But I'm going to stop on that one. That's just some of the material here. I'm going to go back here to our slide here. But as you can see, if you go in here, the key point that I'm trying to emphasize here is that any false, misleading, or deceptive act can end up getting you in trouble with the DTPA. A licensee, of course, taking advantage of the consumer's lack of knowledge, that's another one, their ability, experience, or capacity that is going to be unconscionable is also going to be to the scale of that particular level as well. Okay? Now, my question for everyone for tonight is this. Is number one, does everybody kind of understand the content that's in the classroom at the moment? Everything that has been covered so far. Are y'all good?
Yes, sir.
Okay. Now, for those of you online, is there anybody online that has any questions for me at all? If you do, you can type it in the chat box and I'll answer any questions. I give everybody about a minute just to see if anybody has any questions. All right. Looking like everybody's good online. Okay. So with that being said, I want to come back here, go back to our classwork. All right. So like we said, and those of you earlier, I do want you to kind of go through. If you want your textbook is going to be right here in this link. Okay. There is an optional reading right here called Think and Grow Rich. I highly, highly, highly recommend this book. No joke. It is not an easy read in the beginning. I'm not going to lie. It's going to be boring. Okay. But if you can get past the second chapter, it's pretty much, it makes you rethink how life is. Okay. The reason that I encourage you, and I'll tell everybody this, I utilize Think and Grow Rich for this purpose. Think and Grow Rich is going to have you thinking differently. Most people in this situation, they have ended up basically going in and they were ending up having one way. So what ends up happening is that they go through and they don't end up, they think an old way, if that makes sense. Okay, they think into a situation of, most people were taught you work an 8-to-5 job. Okay, Think and Grow Rich in this situation, the key thing about Think and Grow Rich is it teaches you how to think outside the norm of 8-to-5. Go get a job and work 8-to-5 for the rest of your life. Think and Grow Rich requires you to think outside of the norm. Okay, and we're going to be bringing some things in here and all. But this kind of thinks outside of it. So if you are doing bad in this course, I will ask that you read and you'll write a paper and submit it, and I may curve your grade. So if you're looking for something for a curve, this is going to be your bonus, basically. What we have done tonight was, this is your learning objectives, and this is your course material. This is the PowerPoints and all. You will notice in here that your lecture is going to be here. This is an older lecture. It will be replaced with this video tonight. It will be replaced with it. But this will be where your lecture is. Now, what I want to explain, this is the PowerPoint view. But if you prefer it to be in an outline view, you can print this one off. And I recommend printing this one off, bringing to class, not the PowerPoint. Does that make sense? Okay. Now, in regards to discussion questions, these are your discussion questions. As you can see, I've had 4 people that have turned it in, 4 have been graded, 2 have been assigned. I need everybody to go in and answer these questions, okay? So I need you to go through and make certain that you're completing all of these. These are your 2 questions. These are the things that you need. These are your peer response, okay? I will grade these at the end. I'm not going to grade them through here. Does that make sense? And you'll notice something. There is no time deadline on these. I'm not putting a weekly deadline because we're in a fast track course. So if you want to get ahead, you can, but I don't want you getting behind. Does that make sense? You do have a quiz that you need to complete, okay? You'll go right here, you'll click on this, you will open your quiz, you will submit your quiz. If you do not have access to the quizzes, send me an email and I'll make certain we get it fixed. Does that make sense? But everybody should have access to these databases, okay? There is 10 chapters. We are going to be meeting 10 times, okay? So in that situation, you have a chapter a day that we're knocking out. Now, do you need to go in and do you need to read the chapter up here? It depends on you. If you're a visual learner and you do great with me teaching, you're good. But if you're not, you want to read, there's a textbook. Does that make sense? Okay? All right. Is there any questions for me at all on any of the material so far? Everybody's good. All right. Let me kind of tell you what the plan is. So we will meet 5:30 to 7:30 now. Tomorrow, 5:30 to 7:30, we're going to meet 10 times like that. On Thursday of this week, I may be running a little behind, okay? Because I will have to go to Houston for a closing, and I'm got to be down there, and then I'll be back. So I might be just a little off on Thursday. I'm sorry, Thursday, not Tuesday, Thursday. When I come back, we'll pick up, but we're going to continue. So we're going to do all 5 days here. We're going to do 3 days next week, and then I believe 2 days the following week for a total of 10 classes. Does that make sense? Okay. If you can't make it, I'm recording them. However, by Trek, I have to make certain that you are all ending up. I have to follow Trek's rules that everybody's putting in at least 3 hours a day worth of materials for a total of 30 hours. Okay. So we're going to have our lecture. Lectures are about 2 hours. Then we end up, you have about an hour worth of homework that you need to complete. That gives you your 3 hours, 10 days, 30 hours total. Does that make sense to everybody? Okay. All right. So other than that, we're going to call it a day. If you got any questions, like I said, after the fact, please email me. It's admin@techinstitute.com. Okay. And we will get back to you as quickly as we can. Other than that, we'll go ahead and call this a class, and we will pick back up tomorrow. I will see you all tomorrow. Have a good evening.